So you've been paying top dollar for a self-defense membership, thinking you'll be covered no matter what, only to find out the company can drop you before your trial even begins. That's exactly what happened to Kayla Giles, and the latest developments in her case are stunning. In this video, we'll talk about how this USCCA Platinum member was abandoned by the USCCA after her arrest, why her case has reached the Louisiana Supreme Court, and why every gun owner needs to pay close attention. Imagine you're in a Walmart parking lot for a custody handoff. Tension is high, but you hope the exchange goes smoothly. Instead, your ex-spouse walks over to your vehicle, opens your car door, and you're forced to make a split-second decision to protect yourself. That's the situation Kayla Giles faced. She believed she was within her rights under Louisiana's Stand Your Ground law, which says you don't have to retreat if someone threatens you in a place you're lawfully allowed to be. Once the shot was fired, her life turned upside down. She was arrested and thrown into a legal whirlwind. The larger shock came when the very organization she relied on, USCCA, dropped her coverage before she went to trial, leaving her alone to face a potentially life-altering prosecution. Kayla Giles wasn't just any member either. She paid for a platinum tier membership, which is supposed to provide top-level support. Early on, USCCA did step in, hiring an attorney who believed this was one of the strongest self-defense cases he had ever encountered in his 40-year career. But after an initial outlay of $50,000, USCCA decided that Giles's act of shooting her ex-husband fell under a criminal acts exclusion in the policy. They withdrew coverage before all evidence was in, and well before a jury could determine her guilt or innocence. That decision hit Giles hard. The lawyer who had begun building her defense was let go, and she was forced to fend for herself at one of the most critical moments in a self-defense case. We as gun owners take our Second Amendment rights seriously, and part of that responsibility includes being prepared for the legal aftermath of a defensive shooting. That's why so many people sign up for self-defense insurance like what USCCA offers. We do it because we want peace of mind that if we ever need to protect ourselves or our loved ones, we'll have a legal team ready to fight on our behalf. Yet Giles's story shows how quickly that security can vanish if a claims department decides your actions don't qualify under the policy's language. It's a sobering reminder that your membership might be worth nothing if the insurer pulls out as soon as charges are filed. Giles tried to sue USCCA, arguing that they'd breached the agreement by dropping her coverage prematurely, but she lost because the court ruled the policy didn't cover criminal acts. If you're charged with a crime of violence, the insurer can say you fall under that exclusion, whether or not a jury has convicted you. Self-defense cases commonly involve serious felony charges, at least initially, so there's a risk you'll be labeled a criminal on paper before you have a chance to prove you acted within the law. For a lot of us, that's a problem. You pull your gun, believing you're facing a lethal threat, and in the heat of the moment, you're not thinking, will my membership provider pay for this if the DA says I'm at fault? You're just trying to stay alive. Yet, in the days that follow, if an adjuster or a bean counter decides you violated policy terms, you'll be left on your own. All the monthly premiums, the fancy membership cards, and the promise of coverage may evaporate exactly when you need them most. That's why people are becoming increasingly skeptical of traditional insurance models for self-defense and are looking into alternatives, such as direct relationships with attorneys who specialize in firearm cases. Kayla Giles's ordeal is an example of why it's so important to pick your defense plan carefully. After her coverage disappeared, she was on the hook for her own legal fees, stuck navigating a complicated trial strategy, and facing the harsh reality that a prosecutor could paint her as a criminal. Prosecutors often introduce the aggressor doctrine to argue that the defender caused the confrontation. In Giles's case, the state claimed she was the original aggressor, despite evidence she had retreated to her car. Even so, the court allowed the jury to hear instructions that effectively minimized her stand-your-ground argument. That alone may have tilted the outcome against her, raising serious questions about whether she got a fair trial. These issues reached the Louisiana Supreme Court, which is notable in itself because high courts rarely take on routine criminal defense appeals. The fact that the justices heard oral arguments suggests something was amiss, perhaps in the way the trial court handled the interplay between stand your ground and the aggressor doctrine. The footage from the parking lot, combined with witness testimony, made many observers wonder why the court would conclude that Giles had no self-defense claim. She was in her car with the door closed, and her ex-husband made the choice to approach and open that door. Under Louisiana law, that could be considered an unlawful entry, justifying a defensive response. The real question is whether she had the right to shoot to stop what she perceived as a threat, and whether any earlier arguments or actions by Giles disqualified her from claiming self-defense. During the Supreme Court arguments, the defense hammered home that it's dangerous to give a jury instructions about being an aggressor without concrete evidence that Giles initiated force at the moment of the shooting. The prosecution countered by pointing to her prior behavior and suggesting she might have pulled her gun prematurely. However, one of the justices asked a key question. If someone opens your car door uninvited, don't you have the right to respond with force, especially in a stand-your-ground state? Another justice pointed out that the ex-husband could have simply left in his own vehicle since the children were already in his car. Why come back and open Giles's door unless he intended something more confrontational? It's rare for a Supreme Court to put the burden on the prosecution to explain why the suspect shouldn't have used force in that scenario. The justice's skepticism makes it possible that they'll overturn Giles's conviction if they find legal errors in how the jury was instructed or how the evidence was presented. If that happens, Giles could be retried, and she might bring on a fresh legal team like attorneys on retainer, who have expressed strong interest in defending her if she gets another shot at justice. A new trial could radically change the outcome, especially if the defense can argue more effectively that she retreated to her car, that her ex-husband chose to escalate by opening her door, and that stand your ground protects her from the aggressor doctrine in those circumstances. It also shows the broader tension between insurance-based memberships and legal defense funds that rely on direct attorney relationships. Many gun owners are discovering that working directly with a law firm avoids the issue of coverage being canceled at the worst possible time. An attorney-client relationship is a contract, and there are fewer external factors that can sever that contract. When you have bean counters reviewing whether your case is cost-effective or fits the policy language, you risk losing coverage before the evidence is fully vetted. That's especially distressing if you've paid for the highest tier of membership, under the assumption that it guarantees robust legal defense. The Giles case may also influence public perception of self-defense laws in Louisiana. If the Louisiana Supreme Court rules in Giles's favor, it could clarify how stand your ground and the aggressor doctrine interact. To many of us in the pro-Second Amendment camp, stand your ground should allow you to defend yourself in your vehicle without a duty to retreat, especially if someone unlawfully enters it. I think there should be a thorough examination of whether Giles provoked the incident beforehand. The entire saga is a textbook example of why every gun owner needs to have a post-incident plan. Beyond just training and practicing the fundamentals of marksmanship, you must know what happens the moment police arrive, how you'll secure legal counsel, and what your membership plan or defense fund actually covers. You don't want to be in a jail cell calling a 1-800 number, only to discover a claims adjuster has decided that your actions fell under a criminal act exclusion. By then, it's too late to switch providers, too late to argue about policy language, and too late to salvage the attorney you initially had. No one thinks they'll ever end up in a high-profile trial, but incidents like Kayla Giles's show it can happen to anyone, even people who have tried to protect themselves and step away from a conflict. If you go to bed each night trusting that an insurance-based membership has your back, consider diving into the fine print. Ask pointed questions. Can my coverage be withdrawn if I'm formally charged with a violent crime? What if the prosecuting attorney claims I was the aggressor? Does the policy have a clause that terminates assistance when certain plea bargains or legal definitions come into play? All these issues contribute to the growing conversation within the gun-owning community about alternative support models. Some people prefer attorneys on retainer because they guarantee representation through a direct contract that doesn't rely on an insurance underwriter's approval. Others continue with insurance-based options but make sure they thoroughly understand the coverage. The point is to avoid being caught off guard if the worst happens. We know how aggressive prosecutors can be, especially in politically charged environments where a jury might be swayed by emotion or by incomplete evidence. What happens next for Giles? We're waiting on the Louisiana Supreme Court's decision. If it sides with her and orders a new trial, there's a good chance this case will become a national talking point. We'll see whether a different approach to her defense might finally lead a jury to accept that she was standing her ground. That would be a massive shift for her personally, and it could set a precedent for future self-defense cases in Louisiana and beyond. It could also send a message to membership companies. If you advertise, "We stand by you," it needs to hold true until all legal avenues are exhausted, not just until an indictment is handed down. Regardless of the outcome, Giles's story should remind us to stay vigilant in protecting our Second Amendment rights. It's never enough just to own a firearm or practice at the range. You have to be legally prepared for the possibility of a hostile prosecutor or a membership provider that views your situation in black and white insurance terms. This is real life, and as every responsible gun owner knows, split-second decisions can bring a lifetime of consequences, including legal battles that drain your finances, disrupt your family, and potentially cost you your freedom. Needless to say, if you carry a firearm, you also carry the burden of making sure you can defend your actions in court. Your self-defense membership should be an asset, not a ticking time bomb that might explode when an insurer sees too much risk. Whether you choose a direct retainer relationship with a specialized attorney or stick with an insurance-based plan, at least make certain you understand exactly how and when your coverage applies. And keep in mind, in a stand-your-ground state like Louisiana, the law should protect you if someone unlawfully invades your space, unless a court decides you were the one who escalated the conflict. Those lines can get fuzzy, and that's why legal representation matters so much. If you want to see more updates on this case and others involving the right to self-defense, please like, share, subscribe, and click on the bell icon for more of these videos. Your support helps our pro-Second Amendment community stay informed about legal developments that affect every one of us who carries. We'll be watching to see whether Kayla Giles's conviction stands or if her case is sent back for a new trial that might lead to a different outcome. Either way, her experience has already sounded an alarm for gun owners who rely on membership policies. It's our responsibility to make sure we're not left stranded in a moment of crisis. No one knows exactly how the Louisiana Supreme Court will rule, but one thing is certain. If Giles gets another shot in court, her legal defense will aim to correct any prior missteps, especially the jury instructions and the handling of evidence about who really was the aggressor. Should that happen, we might finally see a resolution that clarifies the boundaries of self-defense inside your vehicle, plus a renewed debate on whether membership plans can cut off people long before the legal system makes its final judgment. Until then, stay safe, stay prepared, and remember that your right to bear arms goes hand in hand with the need to defend that right in court if necessary. We owe it to ourselves and to the next generation of responsible gun owners to learn from cases like these and make informed decisions about our legal protections. Thank you for watching, and be sure to stay tuned for more updates on this and other important Second Amendment issues.